Hi, this is Emily Weisberg, and this is my presentation on the major aspects of the criminal justice system. The first topic I'll be discussing is the primary components of the criminal justice system. There are 5 main components. This is law enforcement, prosecution, defense attorneys, courts, and corrections. Law enforcement plays a huge role. This is because they are responsible for enforcing the laws we're supposed to be following and maintaining order and safety all over the world. They are out in the field to prevent and detect or investigate criminal or crime scenes. Um, Once the crime has been committed, law enforcement officers with reasonable cause can take somebody into custody. They have the right to arrest the offender. After the initial crime has been committed, LEOs can also give testimonies during the court process or lead follow-up investigations if necessary. In other words, law enforcement officers are just the very beginning. Moving on to prosecutors. Prosecutors are lawyers that are directly involved in the constant contact with the law enforcement officers. They represent the federal government or the state and have 3 main acts of duty. These acts of duty include investigating crimes, deciding whether or not to begin a legal proceeding, and appearing in court. Prosecutors work together with police to investigate crimes. And along with having this contact, they also are able to be in constant contact with the victims and the offenders themselves, also witnesses. And after the preliminary investigation, prosecutors could then decide whether there is enough evidence to bring the case to court. If so, the prosecutor must prove that the offender is in fact guilty of the crime. Defense attorneys, on the other hand, are hired by the defendant themselves, or they are hired by the court if the defendant is unable to afford them. Their sole purpose is to prove to the court that the defendant is in fact guilty. The courts themselves are run by the judges. Their overall jobs are to make sure that all the laws during the proceedings are followed. Not only do they oversee the trials themselves, but they also are assigned the jobs of accepting or denying plea bargains, setting bail amounts, or sentencing guilty offenders as well. There are 2 parts of the correctional system that I want to talk about. First is the correctional officers. Correctional officers are always there to supervise offenders at all times, at any public appearance, or whether they're in jail, courts, or prisons. They are always there to make sure the offenders don't do anything that they shouldn't. And then there are correctional facilities and agencies themselves. This can be parole, probation, prison, jail, and in some cases there are newer agencies such as house arrest. Their purpose is not just confining those who have been convicted of crimes, but also rehabilitating them and maintaining public safety at the same time. The next topic in my paper is about the problems within the criminal justice system. As you might already know, the United States has one of the largest prison populations in the world. This already begs the question as to what exactly are we doing wrong here. Some examples might be corrupt law enforcement, something that we're seeing a lot more of often. Problems within the prisons themselves, such as overcrowding and the lack of resources that are going into treatment programs over just punishment for those who have mental health issues or those who have been convicted of drug-related crimes. And when I say drug-related crimes, I more so mean those who have been addicted to drugs who actually need the help while in prison. One of the other problems that I listed in my paper was immigration involving the system. They kind of have to decide what resources they need to come up with and what they need to use in order to deport immigrants when they've convicted a crime here, whether they're documented or undocumented. This creates a problem. They also have to decide whether or not to use resources and remove undocumented immigrants and what types of resources should be used in that case. Also, people who are legal citizens here who bring over immigrants, we have to deal with them and not just those that they bring over. The next topic I'll be covering on my paper was the function and procedure of the UCR program. UCR stands for Uniform Crime Reports, and it is said to be able to measure and calculate the crime rates in our country and all over the world based on statistics that are gathered by this program. This is a law enforcement program that gives reports of all crime rates from all different areas and states that are collected by the police departments monthly. The UCR was put into action in 1929 after the IACP formed the Committee of Uniform Crime Records to form the correct system for gathering uniform crime statistics. Although the statistics themselves are not entirely always accurate because sometimes they are not reported correctly or at all, the UCR still can give people the big picture, and this means that we still know where to look out for, and which places have the worst crime happening. The great thing about the UCR program statistics is that not only do the FBI see these, they are also available to the public. These can date all the way back to 1985 and in some cases even back to the 60s. So people such as sociologists, criminologists, legislators, or anyone else in the general public are able to use this data for their own research or planning purposes. Next, I want to talk about the present-day criminal justice traditions and their precedents. For me, it was easier to find specific things to compare and contrast, so I simplified the main components of criminal justice system into three parts. That is policing, courts, and corrections, which is stuff that I had talked earlier about. Starting with policing, policing can date back to the 17th century and is very much different than it is today, although we are starting to see that we are coming back full circle. This first started in the U.S. shortly after the colonies settled here in 1630. The first system was the watch system, and this was basically made up of volunteers. These volunteer watchmen their only main job was to warn of signs of potential danger, meaning that they weren't really able to prevent any kind of crime or anything from happening at this point. It was more so they were looking out for it and warning people. There were also constables who held small policing tasks as well, and there were also volunteers that would patrol at night. This system was considered to be community-based and was not very effective at the time, although from this, when urbanization started to occur and population started getting bigger and bigger, they needed more and more people, and volunteers were starting to lose interest. They had other things they had to do, therefore this whole system started to fall apart. Eventually, a new system of policing was created, and this was in 1829. This was more of a preventive force and not just people standing in a tower and warning people of stuff that's going on. Crime was now able to be prevented and stopped beforehand and deterred in most cases. Police were now working days and nights, and they weren't volunteers, they were paid. The departments were also led by chiefs or sheriffs, depending on the area, and this is more so how it is today, except now we also have newer technologies and scientific studies and theories that's aiming to improve our system. The UCR program is just one example of how we are constantly improving. In terms of courts, procedures, and sentencings have changed dramatically between the late 17th and early 20th centuries. When crime had been committed, there was no one really there to report the crime besides the victim. Trials were so short that there would be multiple trials in a row before the jurors would even stop to discuss them. And when they would discuss, it could be done within a few minutes, and trials were usually not any longer than 30 minutes each. Also, the jurors would be the same jurors through every trial. They were not really ever rotating out. Lawyers, which is a big thing now, were rarely ever seen up until I think it was the end of the 18th century, and never got very far in the profession because they were always considered to be ignorant and irrational. Defendants at this time were always disadvantaged for all these issues because not only did they not have any time to actually adjust to the situation they were in while sitting in trial, but prior to the trial they were sitting in a jail cell and having to come up with their own case and having to know how to defend themselves because before lawyers were around, they were their own defense. Now our trials are very long. They can last days, months, a year, but this is because the details in trials need to be very drawn out and very closely looked at because there's not any room for error when it comes to the law. Defendants, victims, and prosecutors all carry out a lot of rights now, all individual rights compared to the systems in the past. Victims' rights are a big thing now where victims have the right to certain information and protection and so on. The next topic is on corrections and how the corrections have changed vastly over the years as well. Prior to 1870, men and women were incarcerated and living together within correctional facilities. Not only was this unsafe, but it was also very unhealthy. Another bigger issue back then was the separation of juveniles and adults. Juveniles as young as 6 years old could be tried as an adult and put into prison, an adult prison, up to the early 19th century. There was no real divide between juveniles or adults at that time. Thanks to criminology, we are able to study the different behaviors and the different functions in the brain at different ages, and this has created the evolution of the juvenile justice system so that there can be a separation and there can be different ways to rehabilitate different ages and different genders. On to the next part of my paper. I'm going to talk pretty briefly about the present day value of the Peelian principles. First of all, I'll talk about the history. These 9 Peelian principles came from a man called Sir Robert Peel, who was at different points in time a prime minister, and a home secretary, and others. While he was a prime minister, though, he addressed the issues in the working class. He introduced acts such as the Mine Act and the Factory Act in 1842 and 44. The Mine Act prohibited women and children from working in mines, and the Factory Act had limited the time that women and children could work in factories. When he was a Home Secretary, though, he soon became known as the father of modern policing and created the Metropolitan Police that was based on the 9 principles he created for law enforcement. These principles are the Peelian principles. They are clearly still connected to the policing in today's world, but they are also created the basis for today's law enforcement and the community policing all over the world. Peel firmly believed that the police gained and maintained their power based on the relationship and consent of the public. On this slide, I have listed all 9 of the Peelian principles, and overall, these are still used and applied in law enforcement today. Just going on different department websites, you can see them listed, although most of the time they are reworded to kind of be modernized for that department specifically. They're not necessarily rules or ethics that are enforced, but more so a basis to the way that behavior of law enforcement in the public should be in order for policing to work. The 7th Peelian principle, which reads, police at all times should maintain a relationship with the public that gives reality to the historic tradition that the police are the public and the public are the police. The police being only members of the public who are paid to give full-time attention to duties which are incumbent on every citizen in the interests of community welfare and existence. This is basically the foundation of all the previous principles. It's our duty as well to protect and serve our community. When we, the public, do our jobs correctly and stop breaking the laws and work together with the police, we will start to see that more crime and more disorder are off the streets, and that's when we will feel that the police are doing their jobs correctly. But that involves cooperation on both ends. It is believed that if these principles were referred to a lot more now, the reputation and efficiency of law enforcement would be restored. Moving on, the next topic in my paper is the progression and the procedures that people go through when moving through the system. This is prior to the trial. This was my favorite thing more so to write about because it was something I knew about, but not very specifically. I didn't know the order, and so it was more fun for me to research and find these things out for myself. Starting at the very beginning of this process, before a criminal or a person can be tried or convicted, there has to be legal arrest and charges filed. In order for that to take place, in most cases, there has to be a valid arrest warrant given to the police by the judge. There are only 2 other ways an officer can do this without a warrant, and that is when they have beyond reasonable doubt that this person has committed a crime or they have personally witnessed it themselves. Following the arrest, there is a booking process. The booking process involves having your mugshot taken, being fingerprinted, whether you have been in the past or not. You have your criminal records researched, and you also have to give off all of your personal information, including your physical characteristics and your name, age, and your address. All of your items are seized until whenever you get out of jail. But while you were sitting in jail, you were basically waiting for either your bail to be posted, or you're waiting for your court hearing. If you have committed a serious crime, you will not have a bail available for, or a bail amount available to you. You have to wait until your first hearing because the judge will give you the amount. Typically, the amount will be a lot higher if it's a more serious crime because of the problem with that person going back into the public, the safety of the public. They make it higher so that this person is usually unable to pay it. Or if they do pay it, there's a bigger chance that this person will not flee before the start of their trial. The arraignment is technically the very first court hearing, and this comes to those who have not posted their bail or had to wait until the arraignment in order to get their bail amount. This is the start of the next topic, which is the procedures within the court system. And basically, the arraignment, you will be told what your charges are and whether you plead guilty or not guilty to these charges. Information on your bail will be discussed, whether it's been set or not at this point. It can be readdressed and changed. Future court dates, such as your preliminary hearing or your trial, will be discussed. After your arraignment, you will have your preliminary hearing. This is the process in which the judge is told of all the evidence the prosecutor has against you. They decide whether there is enough against you for them to carry on with the trial. There has to be enough evidence that a crime has not only been committed, but that you have committed it. If your case is still moving forward in the court system, your next court appearance will be for a pretrial. This is basically deciding whether or what certain evidence or what witnesses can be there during the trial itself, or whether the trial will be dropped altogether. Plea bargaining can happen here as well as really any other part, but it seems to happen much more often right before the trial. This will make the trial go by a little quicker, and your sentencing will be potentially more lenient. If this doesn't work out, then the case will go to trial where the jury decides the defendant is guilty or not guilty. If not guilty, the defendant is released from custody, which is called an acquittal. If they are guilty, they are moved to the sentencing phase, which is when the punishment is decided. Some examples of a potential sentence might be incarceration, fines, community service work, rehab, or probation. Some major crimes actually do require a minimum sentence. Either way, the judge will then decide whether these sentences will be carried out in a prison or if they are allowed to serve their time on probation. Usually, first-time offenders of less serious crimes will be let out on probation. After this phase, appeals can be made by any defendant that believes there is an error in their trial. They are referred to as the appellant of the case. Even if they're in the process of appealing their convictions, they are still incarcerated in the meantime. In order to appeal, there has to be real reasons as to why they believe there's an error. It can't be due to just mishearing or misunderstanding. These rarely sway the decision of a judge. Lastly, if someone has served their convicted time in prison, they are allowed to apply for parole under most circumstances. This means that they can serve their time outside of prison under the strict supervision of a parole officer. This will start out with a parole hearing, and the inmate will discuss their reasonings for wanting the parole and why they think they deserve it. Then the parole board will decide whether or not to give it to them. Their decision will depend on the crimes that were originally committed in prior criminal history, along with how well they behaved in prison, and it's also in the best interest of not only the criminal himself, but the public's safety as well.